So our final panel of the day before we bring up our ultimate commentators and open it up for ongoing discussion for the entire day, it's my pleasure to introduce to you Nirs Eisikovits, who is the Associate Professor of Legal and Political Philosophy at Suffolk in Boston, where he co-founded and directs a graduate program in ethics and public policy. He wrote a recent book entitled Sympathizing with the Enemy, Reconciliation, Transitional Justice, and Negotiation. He's also an Israeli attorney. But I won't read his entire bio again, but it's fascinating. His paper right now will be, as we've heard before, Peace versus Justice in Transitional Settings. So I bring you Nirs Eisikovits.
Thank you very much. It's great to be here. Very grateful to Linda and to everybody who organized this for inviting me. If people haven't read Linda's book, they should tonight on mercy. It's wonderful. I get money from the University of Michigan Press. Professor Teitel's wonderful lecture set up what I'm going to talk about really well. What I'd like to do, I think you have in your folders a handout that has some of the main points I was going to make. And so you can follow along with that. What I wanted to do today is to point out, first of all, I should say that I've been trained as a lawyer and a philosopher. I'm coming at this as a political philosopher, thinking a little bit about the question. One of the main questions in contemporary political philosophy and contemporary moral philosophy is the question of legitimacy. What makes an arrangement legitimate? What makes a certain kind of application of power okay, whether it's by the state or by a non-state actor. What I'd like to do is I'd like to go through some of the typical post-war aims that officials, non-state groups have, what people want after war, which is not the set of things that they do want after war is not terribly controversial. Then I want to say something about the relationship between these things that they want. They don't always go together. And again, I think that the fact that they don't always go together is also not very controversial. And they still want them. People have paradoxical desires in this area of life and in other areas of life. And the question is what those kind of tensions can teach us about transitional justice, about the ways of justifying transitional justice, about how tentative transitional justice ideas and programs have to be, about how modest, as it were, we have to be in devising these kind of policies. So let me start by talking about the aims. In making a transition from a violent past into a more final, settled, legitimate government, officials usually pursue multiple goals. While some of these are mutually reinforcing goals, others come into conflict with each other. So it's pretty hard to fully pursue all transitional goals at the same time. So let me describe some of those. One, which we've obviously touched on quite a bit today, is establishing some idea of the rule of law, and this is under part 1 in the handout. So a polity that's accustomed to authoritarian rule is one that has come to adopt a pretty cynical view of the law. Its subjects will see it as an instrument for political oppression, keeping the ruling elite in power and silencing opposition. So it's pretty clear, for example, how Nazi kangaroo courts and Stalin's show trials, to pick two very famous examples, would instill that kind of cynical understanding of law. And one of the most important aims of a transition is to alter that cynicism about law, to make people a little bit less cynical about the political system by setting up the basic tenets of the rule of law. So the subjection of citizens to clear, impersonal, publicly available legislation, setting legitimate standards of procedural fairness, the reintroduction of the principle of legality, according to which there isn't any punishment without a pre-existing prohibition, the functioning professional independent judiciary, and so on. So that's one goal, and that's the cookie cutter description of one classical goal. Another goal is finding, prosecuting, and punishing people responsible for past human rights abuses, perhaps what Ruti described earlier as the more backward-looking part of transitional justice. So most broadly, this aim is motivated by a retributive sentiment. To your question, I don't remember your name, but the history professor, Patricia, so you asked what kind of justice there are. At least one kind of justice is retributive justice. So this transitional aim is motivated by a retributive sentiment, the sentiment that past injustices have to be addressed through appropriate punishment. But the prosecution of past war criminals is, of course, also part of the project of reestablishing the rule of law from the first goal. Such prosecutions involve a commitment to the central facets of what's been termed legalism, the idea that all past perpetrators have to be indicted on the basis of specific evidence pertaining to specific deeds and subject to equitable procedure. So legalism most famously gets its most famous or paradigmatic start in the Nuremberg Trials in the aftermath of World War II. The proponents of legalism that were represented most prominently by the American Secretary of War, Henry L. Stimson, clashed with supporters of a more primal conception of retribution, chiefly represented by Secretary of the Treasury Morgenthau and by Churchill, about what to do with the defeated Nazis. Stimson wanted trials that would be acceptable by American standards. Morgenthau preferred summary executions, the Nuremberg Trials, which, in the words of the Chief Prosecutor Jackson, represented one of the most significant tributes that power has ever paid to reason, signaled the victory of legalism, of the former. So the upshot of a commitment to legalism is the prosecution of human rights violators. And it achieves two things. On the one hand, it reintroduces the idea that human life matters enough that those who threaten it will be subject to serious penalty. And on the other hand, legalism tries to make sure that that kind of accountability is administered fairly. So that's the second aim, the backward-looking aim. The third aim is creating a reliable record of past human rights abuses. Such a record is obviously important for its own sake, as part of the very human project of keeping our history as accurately as possible. It's also helpful in rebuffing spurious revisionist claims denying the Holocaust, for example. And more broadly, in ending the displays of impunity so typical of authoritarian governments. Once there is a record like that, it becomes harder for those who colluded with an oppressive regime to deny responsibility and involvement in past crimes. And war crime trials, truth commissions, both have different degrees of success in creating a history of in creating a record of past crimes. But once they take place, their proceedings are publicly available. You can actually go online and find the ICTY proceedings, and you can go online and find a lot of the Nuremberg Trials proceedings, and you can read the report of the South African Truth and Reconciliation Commission, and you can read Dun Kamas, and so on and so forth. Again, each of these has shortcomings in its ability to produce a historical record like that. The fourth goal is setting up a functional professional bureaucracy and civil service, making the state work, practically speaking, setting up the RMV again so that people could get their license, setting up a tax collection system or recreating the tax collection system so that we can efficiently serve the needs of the population. As with cementing the rule of law, part of the idea is to establish or reestablish citizens' trust in their government. Once basic services are rendered in a reliable, non-arbitrary fashion, ordinary citizens can gain or maybe regain the belief that government's job is to serve them rather than to oppress or to use them. The fifth goal is to help victims restructure and repair their lives, and that's done by attending to their physical and psychological afflictions, by trying to restitute or compensate for lost property, by fixing historical injustices that systematically disadvantaged one group at the expense of another. And needless to say that this project of helping victims restructure their lives overlaps with the second and the third goals. After all, to address the psychological distress of victims, it is helpful to punish those who hurt them and to provide respectful forms in which the stories of victims can be heard. And the sixth goal, which is very, very important, is to stop violence and consolidate stability. Every transition tries to actually stop the shooting on the street so that you can allow for the creation of a stable, viable, economic, civic, commercial life, bring in foreign investments, and so on and so forth. So these are the goals. I'm sure that more or variations of these can be stated, but I think these are pretty common to most transitions. And I think as you try to look at them, it's pretty clear how they can be mutually reinforcing, but how they can come into conflict with each other. So let's try to parse that out a little bit. While all of these goals are politically important, it's easy to see how they can come into conflict. Prosecuting the guilty can harm political stability, as the people prosecuted and their often armed followers become resentful about what they perceive as a politically motivated witch hunt. Post-war prosecutions may also come into conflict with the need to cement the rule of law, as such prosecutions often require departures from the rules of procedural justice. Such was the case with the retroactive criminalization that lay at the heart of the Nuremberg Trials. The doctrine of command responsibility, for example, as a second example, that was first developed at Nuremberg and used later by the International Criminal Tribunal for Yugoslavia and in South America, also departs to some extent from principles of legalism by basing convictions on the status of defendants rather than completely on direct and specific evidence. Even when prosecutions don't threaten political stability, which is a big even, and even when they manage to stay true to the classical principles of the rule of law, they can still come into conflict with the desire to create a robust, comprehensive historical record. When trials are used as your primary mechanism of transitional justice, their very subjection to the rules of evidence means that a lot of information, namely testimony that does not pertain to specific indictments or evidence obtained without full due process, etc., will be excluded from the record. This limitation has prompted some scholars to argue that truth commissions are preferable to war crime trials in that respect, of generating a historical record. Since such commissions are not subject to the rules of evidence, they are able to collect more information, expose a more comprehensive picture of past injustices, and so on and so forth. On the other hand, the evidence that truth commissions collect isn't tested as rigorously as the evidence that the best trials collect. The need to provide victims with meaningful, respectful public forums in which they can tell their stories and receive a degree of acknowledgement that's central to the fifth aim that we just talked about also comes into conflict with some of the basic commitment of legalism. Criminal trials usually focus on the interests of defendants. A respectable criminal trial can't be the platform for victims to tell their stories in a completely uninterrupted fashion. Since the testimony of victims is instrumental for proving indictments, it is most often subject to interruptions and vigorous cross-examination. As a result, a typical criminal procedure can be quite an adversarial experience for victims. This is true in spite of the recent expansion of the role of victims in international criminal law. In fact, an undue expansion of the role creates the grounds for criticizing international criminal law for abandoning some of its original legalist underpinnings. On the other hand, if you watch footage from South Africa's TRC, you see these famous pictures of hearings beginning with Desmond Tutu putting his head on the table and crying along with the people telling their stories. and with paid South African state workers essentially serving as counselors to people providing testimony. So there, the focus is much more on the victims. The ability to provide cross-examinations, at least for the testimony provided by the victims, is limited. And that creates its own problem of legalism, even while it makes a wonderful platform for acknowledgement and recognition. So it's really hard to do these things at the same time, and yet we really want all of them. Finally, the need to set up a functioning bureaucracy, that's a need that's so important for the creation of public trust and the restoration of political normality, can clash with the desire for accountability inherent in the first two goals that we talked about. When most officials implicated in past crimes are purged or lustrated, few competent administrators remain to do the work of government. Especially true given that in dictatorial contexts, almost everybody is implicated in one way or another. Such a competence gap may, in turn, undermine political stability, economic viability, and public trust, all crucial factors in a successful transition. Indeed, worries about the trade-off between accountability and the functionality of a government have led many states to either hedge or give up their lustration policies midstream. Almost every transition since World War II displays all of these tensions, or some of these tensions. The Nuremberg Trials, often viewed as the pinnacle of legalism, or at least its impressive beginnings, were nevertheless based on ex post facto charges. The Spanish transition to democracy was so fragile that it had to commit itself to a pact of forgetting, more than 3 decades of silence about abuses committed during the Civil War and under Franco. Historical justice and the need to preserve the peace came into conflict with the latter, namely the need to preserve the peace, receiving precedence until the 2008 Law of Historical Memory in Spain reversed that trend. In South Africa, de Klerk's National Party threatened civil war if the African National Congress insisted on war crime trials against apartheid officials. The celebrated Truth and Reconciliation Commission, with its amnesty for truth arrangement, was the resulting political compromise meant to avoid both punishment and impunity. The African National Congress's demand for retributive justice went unheeded, to the outrage of many, including, as we mentioned, the family of Stephen Biko, the family of Griffith Mxenge, who sued the Truth Commission, because heeding it would have eliminated the chance for a democratic South Africa. The International Criminal Tribunal for Rwanda, operating in Tanzania, netted some of the genocide's ringleaders, but Rwanda was not able to apply rigorous criminal responsibility to all those who participated in the murders, because hundreds of thousands participated in the murders. Doing that would have taken several centuries. Thus, a system of traditional justice, the Gitcha Trials, was devised. These makeshift grass courts failed to live up to Western standards of legalism. The judges were not professionals. Rules of evidence were followed very selectively. And it failed to produce satisfying punishments. But it did provide a platform from which at least some of the crimes were admitted and acknowledged. And it did manage to empty the Rwandan jails, which contained hundreds of thousands of prisoners. And the tension between practical functionality that we talked about and retributive justice, Rwanda nodded to retributive justice, but eventually focused on functionality. The policy of de-Baathification, carried out negligently in the aftermath of the Second Gulf War, combined with the thoughtless disbanding of the Iraqi army, ended up fueling the anti-American insurgency there, in addition to draining Iraq of many of the people who could actually administer it. Here, too, the commitment to retribution and the desire to create trust by clearing out those associated with the previous regime actually ended up bringing about the opposite effects by further destabilizing the country and harming its bureaucratic competence at the worst time. So how do we think about these tensions? How do we think about some of these tensions? Post-war transitions are characterized by the coexistence of conflicting yet politically and morally important goals. As we've seen, some of these are about doing justice for past abuses, while others are concerned with consolidating stability and creating functioning, competent institutions. The uneasy coexistence of these aims, the fact that they are all so dearly held and yet cannot quite be fully realized together, points to a significant tension between considerations of justice and social utility after war. Needless to say, this tension exists in an ordinary political life as well. When the Obama administration replaces the Bush administration, all of the political appointees that the Bush administration put in place get cleared out of various posts and are replaced by other political appointees, which is in some ways a competence hit to the federal government structure. But the friction between, so this tension, again, exists in ordinary political life as well. The friction between what is morally called for and the way in which leaders must sometimes act for the overall benefit of their subjects has always been important to our understanding of politics. Machiavelli articulated it very famously when he argued that a prince might have to learn how not to be good in order to act in the best interest of his polity. Sartre provides the dramatic depiction and gives the problem its most familiar name, the problem of dirty hands. One of his protagonists puts it starkly, "I have dirty hands right up to the elbows. I've plunged them in filth and blood. Do you think you can govern innocently? Do you think you can govern innocently?" You want your state to have a... By the way, one interesting fact about the Nuremberg Trials, there's the famous first round of the Nuremberg Trials where the Goerings, etc., are put on trial. Then there's several other rounds of the Nuremberg Trials where the more humdrum machinery of the Nazi state is put on trial. And many of them get lengthy sentences. And within a pretty short period of time, the Germans make it clear to the American administration in Germany that the new enemy is the Soviet Union and not Germany. And if they want the friendship of at least West Germany, it would be a good idea to calm down with the second round of and the third round of the Nuremberg Trials. And sure enough, 10 years after those prosecutions begin, most of the people subject to them are out and about having glamorous careers in the new Germany. And that was both a terrible thing to do and the right thing to do. That's the problem of dirty hands right there. It's very difficult to govern innocently. The most important contemporary philosophical treatment of this problem appears in Michael Walzer's famous article, Political Action, The Problem of Dirty Hands. In transitional contexts, this tension is usually labeled the peace versus justice dilemma. So part of what I'm saying is that the famous peace versus justice dilemma, the famous tension between peace and justice, is just a version of a broader political problem, of a broader philosophical problem endemic to politics, namely the problem of dirty hands, denoting that the demands of quiet and stability may well require compromising the morally important demands of retributive justice and accountability. Thus, for example, it was wrong to allow apartheid murderers to get away with murder during South Africa's transition, but if they had been tried as war criminals, South Africa would most likely have erupted into civil war. Similarly, it was wrong to bury Spain's history of violence for more than 30 years after the end of Franco's dictatorship. But had this history been excavated earlier, Spain may well have failed to develop into the liberal democracy that it is today. Viewing the peace versus justice dilemma as a variation of the problem of dirty hands helps us better understand the nature of tensions at play after war. Properly described, peace versus justice is not a debate between proponents of a Kantian commitment to full retributive justice and the cynical realists who are willing, in the infamous words of the Cambodian Prime Minister Hun Sen, to dig a hole and bury the past. Rather, the tension is more properly viewed like the problem of dirty hands as a paradox. Officials, as well as citizens in transitional countries, can currently hold two powerful yet often contradictory intuitions. That in order to establish a legitimate functioning civil society, one must do justice for the crimes of the past, and that to secure quiet, stability, and a functioning government, it is sometimes necessary and morally acceptable to leave past crimes and past criminals alone. So there's no truth versus justice debate. There's a truth versus justice paradox, and that's a very important difference philosophically, because a debate can, in principle, be settled by a superior set of arguments. A paradox can only be described. Caught in the paradox between peace and justice, we might end up emphasizing one kind of intuition over the other after war. But this is not the same as winning a moral argument and doing away with a discredited position. The Spaniards emphasized the need for stability over the need for accountability for about 30 years. Then, when they were confident enough that stability had been consolidated, they switched their emphasis. The Rwandans, after conducting nominal criminal trials in Tanzania, made a similar decision and cleared the dockets by means of their Gacaca courts. Rwanda is now more quiet and stable, but such quiet, as commentators like Philip Gurevich have noted, is an uneasy quiet as long as survivors are resentful about failure to bring perpetrators to book. So stated differently, there's really no debate between peace and justice, like we've said, and like a lot of NGOs and scholars try to claim, only a continuing negotiation between them that at any given point will lead towards one of these intuitions. The best we can do here is to understand their co-equal status, settle on a policy that lies on the continuum between them, and constantly reevaluate. In spite of the fact that peace versus justice tension is merely a specific manifestation of the problem of dirty hands, there's an important distinction that has to be observed here. While the tension between justice and social utility, while you find this problem of dirty hands all over and all throughout normal, regular, settled democratic politics as well, this tension is central and definitive of political life during transitions. In consolidated democracies, such tensions can be alleviated by legal institutions and traditions that embody conclusions about how to manage these trade-offs between justice and social utility. These institutions and traditions include a constitution, a body of accepted constitutional jurisprudence, a respected high court with powers of judicial review, and so on. Part of the role of these institutions and traditions is to provide guidance about which trade-offs would seem most justifiable given a comprehensive interpretation of a state's legal and political history. But transitional times are exactly the periods in which these institutions, traditions, and interpretive principles are first being tried out, are first being set out. When the argument arose about abuses of executive power in the United States following the September 11 attacks, the debate could take place on the background of a history of executive power grabs and the responses to them. Jefferson's requisitioning of funds for the military without congressional approval, Lincoln's suspension of habeas corpus, and so on. In a transitional context, that long and important political discussion is just not there yet. More precisely, the very point of a transitional period is to set up the institutions and methods responsible for having that exact debate. So the upshot of this predicament is twofold. It's harder for transitional societies to resolve peace versus justice decisions because the traditions and institutions so important for navigating these questions are not yet present. At the same time as it's harder, the very act of creating these institutions inevitably creates situations where peace and justice must clash. The need to quickly set up a competent court and police systems to allow for stable government may well require hiring administrators that were tainted by the previous regime. The need to attract foreign investors and maintain peace in the street may require some compromises on the extent and length of criminal proceedings against past perpetrators, and so on. So, to recap what I've been saying, the tension between peace and justice is especially pronounced in transitional settings because creating the basic institutions of governance is more likely to raise it, and because the guidance available in settled context from the existence of these kind of institutions is missing. And to this dual explanation, we have to add that the conflict between peace and justice is further heightened in transitional situations because the political stakes are uniquely high during these moments. If a transitional society cannot consolidate peace and functioning government, the very effort to create a decent new state suffers shipwreck. This kind of fragility, where the entire political project is at stake, is more likely to float peace versus justice dilemmas than a specific crisis in a consolidated democracies. Such localized crises typically implicate localized endeavors, not the existence of the entire political system. So, to sum this up, I've been arguing that the peace versus justice dilemma is especially prominent in transitional settings, that it's especially important to get the negotiation between the two of those right in these settings, given the high stakes, and finally, that it is especially difficult to get it right, given that all of the guidance for getting it right isn't actually there yet. What this argument implies is that the standards for justifying peace versus justice trade-offs in transitional settings are different and probably less stringent, less tough from those in settled context. It raises the possibility that the process of consolidating a democracy cannot be subject to the same moral standards that we would use to evaluate the regime that that process hopefully produces. Consider again the stark examples we had mentioned earlier. Had South Africa held itself to legalism in its transition, there would be no democratic South Africa today. Had Spain held itself to cosmopolitan standards of justice after war, there would have been no democratic Spain today. Transitional justice, if you want, is sui generis under this understanding. It's a enclosed, morally speaking, it's an enclosed world, subject to weaker standards of legitimacy than what it creates. Or if you want to state this even more starkly, you cannot create democracy democratically. I think something like this, or you cannot create democracy with the same standards of democratic behavior that you would expect from the final result. I think this is what Burke had in mind when he famously argued that a veil has to be drawn over the beginning of all nations. I think that point can be overmade and overstated, but I think, like much of what Burke says, it has a kernel of deep truth in it. On the other hand, it should also be noted that this kind of line of argument can easily lead to moral complacency about what is allowed during transitions, or, for that matter, about how long a state should be allowed to view itself as transitional, and thus exempt from our best formulated expectations about justice. Characterizing transitional settings as those in which the tension between peace and justice arises with special intensity is only a first step. Future theoretical work on this can help provide guidance on how to conduct the delicate negotiation between these two poles. The task here is indeed challenging. The theorist has to blend normative theorizing with historical reflection on what has and hasn't worked in past cases in order to figure out when and how to temper the demands of justice by prudential considerations and vice versa. Such blending suggests that non-ideal theory can be especially useful for thinking about the dilemmas of transitional justice, but I don't really have time for justifying that. That normative or ideal theory actually is not very, which is the most prominent, most accepted way of theorizing in contemporary moral philosophy and contemporary political philosophy, is in some ways deeply inappropriate for this subject matter. I think it also hints that some of the least likely thinkers, historically speaking, are perhaps the most interesting for thinking about a philosophy of transitional justice. Machiavelli, who in The Prince and in other works spends a huge amount of time talking about the risks of newness, the risks of a new regime, of the challenges of setting up a new regime, and who I think is wrongly read simply as a proponent of political realism. And Edmund Burke, who's read primarily as the father of conservatism, and that I think again is a very reductionist reading. Reflections on the Revolution in France, his magnum opus, is actually a book about transitional justice, is actually a book about what it takes to set up a new social order, what the risks are involved, how long it can take, and how much you have to wait before you can become enthusiastic about it. So I'll end here. Thank you very much.
Hope Metcalf from Yale Law School is the director of the Arthur Lyman Public Interest Program. She co-teaches the Lowenstein International Human Rights Clinic right up the street at Yale. Katrina Cessna, a third-year law student who is president of our Society for Dispute Resolution. She's on moot court and has interned at New Haven Legal Assistance, the American Civil Liberties Union, the Commission on Human Rights and Opportunities, and is currently at the Office of the Public Defender. Emily McConnell, also a third-year law student, associate editor for Our Own Law Review, president of Outlaws, has worked at Quelf, and is currently interning in Superior Court. So, Professor Metcalf, would you kick us off?
Great, it's my pleasure. Thank you so much for having me. This has been a really wonderful day. And special thanks to the students. I organize a similar event every year. I know personally how much work goes into it. So thank you very much. And also thanks to Linda for facilitating this conversation and for allowing me to meet and be inspired by so many people. So I'm very grateful. So I thought that one contribution I might have is to reflect on what Nir is talking about just in one context, and to sort of, I think test would be an overstatement, but to think about the implications of what it means to argue that transitional justice is, as he said, morally speaking at least, sort of an enclosed and a closed system. And so I come at this subject probably from a somewhat idiosyncratic background. I'm a human rights lawyer, but my work focuses on the United States, and I've spent most of the last decade engaged in post-9/11 cases, and specifically I've represented quite a few either family members or individuals who were subjected to torture in the name of counterterrorism post-9/11. And so as I was reading that piece, and actually throughout the day, that's been sort of the frame of reference that I bring to this conversation. And as a first matter, I want to just recognize that all of the subjects that we're talking about have enormous emotional overtones, not to mention political, moral, et cetera. Certainly when we talk about post-9/11, that has a different moral and emotional valence depending on where you sit. As someone who was in New York on 9/11, I know I have multiple reactions, even to the phrase. So as I want to offer these comments with a spirit of compassion and humility for the many perspectives that people might have on this subject. So I was listening to the talk, and as I read the paper before today, thinking about the implications of Nir's argument, I take there to be sort of several main points, which probably by now are familiar, but just to repeat them, because at least for me it will be helpful. So in the context of conflict or immediately post-conflict, peace versus justice debate that's so familiar to all of us is not an either-or proposition. Rather, it is, I think, an argument that cannot be won, as Nir describes. And secondly, and relatedly, it is not so much a question of a debate, but rather a paradox, a sort of lived paradox of being in this state where it is peace and justice, peace versus justice at the same time. And it is that paradox that is a defining feature of transitional societies. And then sort of growing from that, the implication is that trade-offs in that context may be justified during these, what we are calling transitions, that would not be justified in settled societies or settled democracies. And the paper then offers that the next stage of research and thinking would be to develop a methodology to help guide either practitioners, scholars, leaders, to better navigate these unsettled waters, the paradox that those going through transitions must themselves experience. So my question is, given my context and where I come from, is what does it mean to live in a paradox? And when is that paradox tolerable? When is it an excuse to deny or to delay justice? What is the role of the law in setting the boundaries as for when do we know that we're in transition so as to justify these trade-offs, if trade-offs are just to be justified? And what might law tell us about what trade-offs are permissible? So there's obviously a lot to be learned and a lot at stake. And I thought I would just offer a very quick summary and sort of set of thoughts about the transition over the last decade as the United States has or hasn't grappled with a set of at least allegations of actions that in other contexts might be remediated through a transitional justice framework. So the familiar binary, it seems to me, of peace versus justice in the US post 9/11 was met with another binary that became kind of very pervasive, which was security versus liberty. And we heard consistently discussions, and we still do today. It's basically a truism now that in order to preserve our democracy, one had to sacrifice liberty in favor of security. And many, many scholars, including some that are cited in Nirs' paper, sort of tried to grapple with this. What do we make of it? How much liberty? How much security? And it was on the background of that liberty versus security conversation, both that abuses took place. I'm not going to go into depth, but so as Abu Ghraib would be one example. Other examples would be the incommunicado detention and interrogation of terrorist suspects here as well as abroad. And so the liberty versus security framework was embraced very explicitly by the Bush administration and has since Obama's election has also been embraced by the Obama administration to sort of explicitly say it's time to turn a new page. We're not going to look backward, we'll look forward. So for those of us who have worked with the families and individuals who are affected personally by these policies, grappling with what justice means in that context has been very difficult. So in the words of one of my clients, who is the mother of a terrorism suspect who was detained incommunicado and tortured, she wanted to know what happened, why did it happen, and she wanted most particularly to know that her suffering and the suffering of her family would not have been in vain and that it had some greater meaning. Namely, her greatest hope was that nothing like that would happen again. And the way that advocates tried to accomplish this was through some very familiar American mechanisms. We're good at filing lawsuits, it turns out. We were less good at winning any. I was part of one case which was out of probably about 10 or so cases that sought civil remedies for torture victims. My case was one of only two that even made it past a motion to dismiss. So in other words, in that forum, there was never a chance to air any facts. Allegations, of course, were presented in complaints, but courts, there were numerous doctrines under which courts said that this is actually an issue that is so divisive, so explosive, so threatening, just in its very nature, that we're not going to even consider having a hearing, let alone reaching findings or finding culpability or compensation. So with the civil court system more or less closed, and with habeas proceedings, which I think do not offer kind of the type of forum that we would have in mind for the sort of justice that we've been talking about, and with criminal and military investigations that have really only produced a handful of prosecutions that I think, again, don't provide the sort of form that we're talking about. A group of lawyers and scholars and other advocates on a bipartisan basis created something through the Constitution Project that was called the Detainee Treatment Task Force. And the idea was to provide almost a private civil society version of a truth commission that would review the public records in as objective way as possible, do interviews with as many people from the various stakeholders as they could, and then issue what was meant to be viewed as, if not definitive, then at least balanced findings. And that was released earlier this year. I think for those of us who have been involved in this, we imagine that this is just one step and towards a longer kind of either reconciliation or conciliation process. And I guess just to turn back to Nirs' paper, I take it that where the implication, I think one implication I take from Nirs' paper is that where peace is secure, where despite the threat of terrorism, I don't think many of us are living in day-to-day fear for our physical integrity here in the United States. At least that would be my claim. There should be a greater imperative for justice. Yet, from where I sit, another paradox for settled systems, and I imagine that the United States is not alone in that respect, less, not more justice may be available, as there isn't as urgent a perceived need to settle a score or to accommodate various groups. And that's particularly true when you're talking about a very distinct and discrete minority, such as Muslims living in the United States or abroad. And this is not surprising, of course, that would be the case. We have many examples of justice not coming when it's called for. But it makes the project of transitional justice in the context in which it's happening, so whether South Africa, Rwanda, Kenya, seem all the more extraordinary to me as an American. And it then conversely makes the task of continuing to pursue justice for those of us who are working for justice in the United States and to combat complacency among our own colleagues and compatriots all the more urgent. Thank you.
Thank you. Kate.
So I'd like to echo Professor Metcalf's thanks. I appreciate everyone giving me the opportunity to speak. I'm going to keep my remarks pretty brief, but I wanted to say that I do come at this from a background focus on poverty law, indigent law, in several contexts, between working at the housing unit at New Haven Legal Assistance, at the American Civil Liberties Union. Again, oftentimes we were handling cases pro se, or rather for folks who would have otherwise been pro se, didn't have any means to bring their cases, but did have civil liberties violations that they were complaining of. And now, finally, in the criminal context at the Public Defender's Office in Middletown. So what really resonated for me when I read Professor Eisikovits' paper was the way that these typical post-conflict aims, that I see them play out on a daily basis in the criminal defense system. It's no secret that our criminal justice system sort of impacts disparately in the African American community. The figures that I looked at showed about 12 to 13% of the U.S. population is African American. They make up about 40%, that's a conservative estimate, of the justice system, or of the prison population, rather. And time again, I hear when I'm speaking with clients these same sorts of concerns that are raised, the same sort of tension. So what that got me thinking about was that considering peace versus justice as a paradox is a little bit depressing in some ways, because the root of this inequality, I think, is something that happened well over 100 years ago now. It's the end of slavery and the sort of reincorporation of African Americans into our society in a way that should put them on equal footing, but perhaps it's arguable hasn't and continues to cause problems. And it also made me think, at what point does post-conflict governance evolve out of that transitional period? At what point do we stop saying, okay, well, the trade-offs, that looser standard that we apply as we're establishing democratic regimes that are going to guide us going forward, at what point do we say it's not okay anymore, that standard is perhaps less than we would hold ourselves to once we are settled? I think the trouble with the paradox is that if these competing aims never truly resolve, then we never truly come to a settled point where we can start applying that higher standard. We never know where that transitional period ends. So, for example, in establishing the rule of law, many of my African-American clients have said to me that they feel like there are two systems of justice, one that applies to them and one that applies to everybody else, people with money, people who can afford to obtain a private attorney. They talk about divergent punishments for the same crimes, that they've witnessed people getting. They talk about, in a lot of ways, we talk about creating a reliable record. And I think something that really resonated with me was the discussion of the rules of evidence blocking out a lot of important facts. So many times when I walk into the room right before arraignment and I'm ready to interview, they have so much to say, and it's so important to them, and they don't ever really get a chance. And we always have to say, well, now's not the time to talk about this. Don't say anything about this. It's arraignment. We'll talk about it later. And I understand that this is, like I said, over 100 years later now. We're not talking necessarily anymore about a post-human rights violation trauma. But at what point do we say that people have to just move on and get over it if they've never felt heard in the first place? If they understand themselves to be victims of a system that applies to them in a disparate fashion, that trauma sort of radiates out from the initial injustice of slavery. At what point do we say, those things aren't important anymore and you just have to, those don't apply here, you just have to move on? And then I think another way that there's a lot of parallels to be drawn is between that fifth tenet of helping victims restructure and repair their lives. I think, again, we see time and time again that isn't a focus of the criminal justice system, that if you're looking at the victims as African Americans who are sort of targeted by the criminal justice system, that the focus isn't on helping them get back out into society, helping them become functional members again. It's sort of, replaced by just a continued reentry back into the prison system because I think we as a society have just thrown up our arms and said we don't know what to do. So one of the things that, as coming to it from an ADR perspective, somebody that's involved in a lot of alternative dispute resolution, is I thought it doesn't necessarily have to be too late to correct some of these problems, even though the transition out of slavery and into post-emancipation is well over 100 years old now. I think there are things that we can do to ease some of this tension, and I think one of those things would be truth commissions. I don't think that it has to mean that because the people who were initially impacted aren't around anymore, that's an endeavor that doesn't have some meaning and that wouldn't have a place in the ongoing evolution out of this post-slavery transition. And then also an increased role for ADR processes as sort of a gap filler or a mitigator of the tensions between these goals. Because so many times all that people want is to feel heard. I think that it would alleviate, for example, the conflict between creating a reliable record if people were allowed not only a choice between either trial or, something else, but if we were to do things at the same time, two paths of the trial, the legalism, strictly formatted types of approaches, as well as a mediation forum or a place where we could have a forum just for people to talk, so that maybe it isn't an evidentiary record, but just just as a place for folks to express some of their concerns. So those are my remarks. Thank you.
Thank you. Emily.
Hi, I'm Emily McConnell, and I would like to thank everyone, as everyone has thanked before, so thank you, everyone. And I took, once again, a third different kind of lens in viewing this topic. I have done a lot of work in politics throughout my life, started pretty early on. I've done policy work, campaign work. I've worked for interest groups and various other organizations. And while reading this particular piece, I was thinking about our government specifically and how these principles relate to it and just how our political system works in general. And I found the argument within the paper that the transitional justice is very different in some ways than original or normal justice. However, I believe that some of the same principles can be applied as far as goals or ideals to the system that we have here now. One of the main issues I believe that we have is that we have such an adversarial political system. We spend months, years sometimes, going through and attacking one another in preparation for elections. And then once all is said and done, you have a winner and you have a loser, and then you all have to work together. Even though you're all in the same, you're sitting right next to someone from the other party that didn't win and you did, and yet you're expected to move forward with that. So as far as one of the main phrases today, just going back, not just with this piece that stuck out for me today, was the thought of reconciling without an apology. So how do we take two sides that aren't going to say, you know, what I said about you, I knew it was wrong, and I put it out there anyway. So I'm sorry about that. But so they're obviously not going to say that, but how can we make it so that we have a more cooperative system? A system where we can progress together rather than it being conflict throughout the whole ordeal. And another main point would be the accountability that has been raised multiple times today. How do we keep each other accountable and have an effective government at the same time? Otherwise, just to have that much high-level, high-tension conflict and then expect people to come together after that, maybe we can apply some of these same principles to those ideals. The other, and I'm going to be pretty short with this, is that I do think that standing governments can benefit from these ideals. And although I don't think that we necessarily have the answers to many or any of these issues at this point, I think it is important to ask similar questions to the system as it stands now.
Thank you. So, first of all, I want to thank all our commentators. And I want to ask Nir if you'd like to make any comments on your comment.
Sure. Just a few brief words. Maybe one comment for a point that recurred in all of the comments. I think the analogy to the settled contexts is a really interesting one. Specifically in the American case, the U.S. I want to state emphatically isn't a transitional country anymore, and the moral vacation should have been over a long time ago. And I don't know exactly when to pinpoint the historical moment when the transition ended, but it's been over for a long time. I'm not sure that there's a theory for pinpointing the exact moment when transitions end, but again, you know it when you see it, and it's over. So that's one thought. A second thought to your really nicely phrased question, Hope, about what does it feel like to live in a paradox, or what does it mean like to live in a paradox, or what are the implications of living in a paradox? My own sense is that the implications of living in a paradox have to somehow involve humility about your degree of confidence in a given policy. I'll give you another example, which I talked about in the paper, but I didn't want to read out. Another example of a paradox in our moral life that philosophers talk about is this idea of moral luck, the paradox of moral luck. It's a paradox about how moral intuition works, and specifically, we have this strong intuitive feeling that people should be held accountable only on the basis of what they can control, only on the basis of what they tried and wanted and strove to bring about, on the one hand. And then we have a completely contradicting moral intuition that says that people are held responsible on the basis of the bad results that came about from their actions, even if they didn't control them. And so you drive home after being very, very tired, after not sleeping as much as you should have last night, and you get home safely and nothing happens, or you drive home under the same circumstances and, God forbid, you hit somebody. Based on the first intuition, both of these people did the exact same thing. And the fact that a kid did or didn't jump in front of the car doesn't make a difference. Based on the second intuition, they did something terribly different. And in fact, if you look at the legal treatment of these cases, the person involved in the second context is going to get punished much more severely than the person involved in the first one, at least in many jurisdictions, even though they did do the same things. And we do have both of those senses. So where does that leave us? And again, my sense is it leaves us with a need for humility, with a sense of, as you look at the guy who did hit somebody, there, for the grace of God, walk I, and you become a little bit less self-satisfied about what you're involved in and what you're not involved in. I think, so that's the only beginning of an answer I have to that question.
Can I quick response?
Sure.
So I think that framing is really helpful, and what it makes me think of is Linda's earlier comments, as well as there's been a ripple throughout the day of talking about process and how process can either encourage or discourage humility, which I think in this context might be another way of saying honest exchanges, namely that by approaching a subject or others with humility, we can actually have a real conversation. So perhaps a way to operationalize your value of humility might be to think about what are the processes or institutions that will encourage that.
Great. So what we're going to do is take like 2 questions now, and then without a break, we're going to segue into some people who are going to help us wrap up and open up for questions of anyone. So, Annabelle.
I was interested, thank you for your really interesting talk, interested in the utilitarian aspect of, in some instances, not being able to pursue the perpetrators. And then I was comparing that with other practical instances where it's not possible to pursue the perpetrators. So in New Zealand, we have embarked on a lengthy, you could say, a truth and reconciliation process of grievance hearing in regard to our Indigenous people, who constitute 50 to 60% in the prison population, while they constitute 14% in the population at large. So there are major structural issues in regard to our relationship with Māori. So in that instance, the whole focus has been on the historical victims of a process. Not possible to go back to the original perpetrators, but the current government takes kind of a moral responsibility for what has occurred in the past, and collectively, New Zealand population has done as well. I was wondering, in regard to coming back to the examples of the utilitarian decision not to prosecute the perpetrators, that in those instances, would it then be sensible to focus strongly on the victims and to provide more attention to their needs in terms of compensation and recognition, despite the fact that the perpetrators, for whatever reason, won't be pursued?
I think it certainly would be, although I think in fairness, it's important to say that sometimes their needs are exactly that the perpetrators be prosecuted and pursued, if you ask them. And bracketing that, I would completely agree, but that's a big bracketing.
Linda?
Thank you all. That was really a wonderful panel. And I wanted to pick up on Hope's suggestion that perhaps in settled systems there might be less justice than in transitional ones. And that transitional justice moments may not be quote-unquote moral vacations, but that might actually be a more authentic place where all of these different voices get heard and all of these different injuries get aired, which, as Kate was pointing out, often don't get heard because of the sort of formal rationality of law. And so, not surprisingly, you might not be surprised for me to say that rather than that there might be a place for the view that the transitional justice, the compromised justice, the humble justice, the merciful, peaceful justice, where you're really not sure of what to do, is actually the real justice.
Pure.
Yes,
That's very powerful.
Very.
Can I take it the other way around and ask about the peace? But I learned through both what and also what Hope said. I know that the professional hazard of doing philosophy is to ask you what you mean by the word peace. And what I got was a stability, a peace and quiet, emphasis more on the quiet. I call it peace in the street. I find that a very procedural type of thing rather than a substantial piece. And where I come from, or that's another way of looking at it, we always say peace is not going to be worth anything if it's not a just peace. So rather than talking about a different justice, I would like to talk about a different peace. And if it's not a just peace, I don't know if I would really call it peace. I would call it all these other things that, something that's organized and well attended and controlled.
Obedient,
I'm
too.
happy to call it all of the other things except peace. The peace versus justice label is a label that is sort of hoisted on this discussion, so it's used. But I think exactly at the moment of transition, mainly what we're talking about is a conflict between social stability and the retributive sentiment. And that's the major conflict I had in mind. Now, I think I'm very sympathetic to the line that you presented in the morning, that there can be moments and glimmers of reconciliation even in the midst of crisis, or there can be moments of, I probably would call it, rather than reconciliation, people understanding that they're also human beings apart from their ethnic identities. And those two I don't think are inconsistent. But what I do hope to have offered is, in a way, a definition of transitional moments. And transitional moments I would define as those where, on the one hand, everything is at stake. And after 9/11, painful as that was, not everything was at stake here. The Republic stood, and everybody understood that it would continue to stand. And where there's zero guidance from traditions, constitutional jurisprudence. And that combination, I think, to put it in the most stark ways, because we are Israelis, that combination does justify a moral vacation. And any other combination, I don't think, justifies it. A brief moral vacation, as brief as possible.
Great. Well, I want to thank you all as we transition to our final part of the day. So I'd like to now invite some very important people down here to help us synthesize all of this, and they will kick off as well some open discussion. And those would be Sarah Gruber, Diane Cooper, and Kelsey Crivera, who, of the people who are currently students at the law school, are the three who really did most of the work. And they will, as they come down, I think that now would be another good time for a round of applause for these three women. So they each have prepared some brief synthesis and remarks, and would it be fair to say it is our goal as well to then allow any other comments and questions to any of our speakers who are still here and still be out of here at 4 o'clock? Are we on that track still?
Yes.
Since they're the only people in the room who didn't tell me how long they were going to speak.
We'll try to keep it brief. I do want to take just a few minutes to thank some very important people. First, I'd like to thank Linda Meyer, because without her, this would have never happened. This was something that she talked to us about starting last year, and it's been really just such a process, and I'm so honored and privileged to have been able to work with Professor Meyer and also with Professor Cass and with David Ives and the Schweitzer Institute and Center on Dispute Resolution. It's really been such an amazing experience, and I thank you all for that. I'd also like to thank Sarah Gruber, the Law Review, the staff of the Law Review, everybody has been wonderful, so much help. Sarah has done so much work for this conference, and I can't thank you enough. I'd like to thank Kelsey Crivera for all of her help and her interest and her passion about this topic. It's been amazing to work with her and just hear all of her thoughts and everything that she's done to put this together and make this a reality. I'd like to thank all of our speakers for traveling here today and preparing these wonderful papers to share with us so that we could talk about this really important topic and have these dialogues. And it's been such a great day. I'm so excited about how it's gone. I'd like to thank all of our panelists for coming and reading the papers and preparing very thoughtful remarks and really taking this so seriously and understanding how important this was. And thank you to all of our attendees. I know it's a long day. It's a gorgeous day outside on a Saturday, but thank you for coming and listening to this and really participating in the conversation. So we are going to briefly talk about some of the things that stood out to us today, just as common themes throughout the whole program. And then we'll open it up for questions after that, as Professor Cass said. So throughout the day today, we've heard of examples of war and human atrocities in countries that are in transition. What stood out to me as a common theme was that transitional justice has a human aspect underlying everything that happens and the stark humanity of the topic. In Professor Teitel's remarks, she mentioned that we are dealing with the most difficult problems of the human condition. And this comment made clear that within any of our legal or political solutions to these described atrocities, there always needs to be a recognition of how deeply personal these events are to people and how emotional the situation really is. We talked today about acknowledgement, and we talked about the importance of language and the voice of the victim. We talked a little bit about helping victims restructure their lives and pointed to the importance of whatever regime or whatever transition process we take, that it has to be the right one because the stakes are so high. And we also discussed the efforts of memory makers who are fighting to have their interpretation of what happened heard and accepted. I truly appreciate that, the human aspect of this, and I thank you all for your contributions, and everyone's comments were fascinating today, and I truly appreciate everyone's being here.
Yeah.
Okay. Thank you, Diane. It really was a wonderful day. I was very happy to be here. I guess some of the things that I would take from today, as far as general themes go, is that in order to effectuate change and to effectuate justice during a time of transition, there needs to be recognition and acknowledgement of the past. and what has actually occurred, and that some people were hurt, no matter who those players are, that there needs to be some kind of recognition and acknowledgement. And I think that inherent in that is that if it needs to be changed, that the narrative and the discourse behind that recognition and acknowledgement, there needs to be some kind of forum where that needs to be changed if that's necessary. And within that forum and that discourse, I think it's really important that everyone that was affected by what happened needs to be at that table. You need all hands on deck so that not only you can change that narrative or continue to perpetuate that narrative, not only for the current generation, but generations to come, and that whatever that narrative may be, it's important, as Professor LaPlante was discussing, that whether that's a truth or a collective memory, that everything is brought together and it's truly reflective of who was affected by whatever conflict that changed people's lives. So not only that, I think that by building that forum and changing that narrative, that during the course of that, there needs to be some coalition building to effectuate change, and that no one person is going to be able to do it all, and that we need to work together to build a coalition that can make some changes to achieve justice. And I think that one of the things that's important as far as building that coalition is doing what we've done today. Just having a forum where we can talk about the issues, what's gone right, what's gone wrong, and how we can move forward. So those are my thoughts.
Great.
Thank you, Kelsey. And I just, again, want to do lots more thanking, as Emily put it very well. Really, thank you all for coming, and thank you for all the hard work, everyone here who, even just by coming and listening, has really just been a delightful day. I just very briefly want to relate what I've heard today to a very personal level. One of our law review members, Kim Osborne, was saying, when you talking about collective memory, about how she remembers the Christmas and smells it and tastes it. And so sitting here today, I really tried to relate everything I heard to how I am as a person. And when I come across problems or issues, do I acknowledge the other person? Do I, as Hope said, approach things with humility, with empathy, not necessarily an apology? Even if there was a moral vacation, it's really, I think, an exercise in evaluating who you are and how you approach your own problems. And really that does tie into the ADR perspective. But just recently, I've come to know that I need to always step back and look at the approach I'm taking and my lens. And I think that's an important lesson for everyone, almost in every context. But that's a theme I see, and it's a theme I advocate, because I think it's important, and I think it would solve a lot of problems if we could all step back and acknowledge each other and acknowledge our approaches. So that's really what I took from today, is not only how we analyze transitional justice and we analyze it in the international context, but how we can still bring it home and practice it as people. So Professor Cass, I turn to you.
Day by day, day by day. Great. So I want to thank you, ladies, for your comments.